This year's theme is Preserving America's Four Freedoms, the Heart of Our Democracy. My name is Charlie Whelan. I teach public policy at Tuck, and I am the moderator for today's lecture. On behalf of Osher at Dartmouth, I want to welcome all of our in-person attendees here in the Lebanon Opera House, which is just a beautiful place to be this morning. I also want to welcome all the members and non-members who are participating via live stream, particularly our sister Osher Lifelong Learning Institutes at Brandeis, Towson, University of Connecticut, University of Georgia in Athens, University of Massachusetts in Boston, University of Michigan, University of Richmond, University of Rhode Island, and University of Virginia. So all of you around the country, welcome, and glad you could be with us. Obviously, a lot of work goes into producing and supporting each of these events in the series, so there are a lot of people I want to thank, and I apologize in advance for those I may leave out. We have the 2025 Summer Lecture Series Committee. We have our dinner hosts last night, Peter and Susan Brink, and we got a preview of today's talk, so I can assure you it's going to be remarkably interesting. All of our volunteers here today and also working elsewhere to make the series work. Obviously, the Lebanon Opera House for hosting, the technical support staff, who, if you've ever been behind here, is Warren, who actually got me out to the stage and rescued me when I got lost. Junction Arts and Media for their live streaming technical help. It's fantastic that we can reach so many people around the country. The Osher at Dartmouth staff, and of course, today's speaker, whom you're going to be hearing more about, Rachel Rosenbloom. Special thanks to those who have financially helped to make this possible. So our platinum sponsor is the Jack and Dorothy Byrne Foundation. Our gold sponsors are Doyle and Lauman, Kendall at Hanover, and the Village at White River Junction. And our silver sponsor today is JMH Wealth Management. So thanks to all of those people. Please give them a hand for bringing us here and making this possible. All right, some basic rules of the road. If you're here live, take a look around, make sure you know where the clearest exit is. If you're at home, I suppose you should do the same thing. Right? It's not on the script here, but it does make sense, right? Who knows? You're all over the place. All kinds of things could go wrong. More important, or maybe not more important, we have buckets. There's one basket here, one in the back. And after you hear the talk, or maybe before, you write down your question on the index card. And then for those of you who are online, type it in the chat. This is a really nice feature of the event. What we'll do is at the end of the talk, we'll take a brief break, and then we will compile the cards and ask the questions that come up frequently, and then we'll reconvene at roughly 10:30, and we'll do a Q&A based on the questions that have come in through the chat and the index cards. If you are online or on the cards, if you want to note your name and where you are online, we can also refer to you when we use your question. There will be a post-lecture discussion right after the Q&A, and that will take place down the block, 1 Court Street in the Osher classroom. That's 3A on the 3rd floor. And it's going to go roughly from 11:45 to 12:15. Now, the exciting part of the day, when you get rid of me, is I get to introduce our speaker, Professor Rachel Rosenbloom. And it is, again, based on what I heard last night, it's a real pleasure to have her here talking about a really timely and important issue. Professor Rosenbloom is a professor of law at the Northeastern University School of Law, where she teaches courses on immigration law, refugee and asylum law, and administrative law. From 2017 to 2020, she was co-director of the Northeastern University Immigrant Justice Clinic. Her academic work is focused on the immigration enforcement system, the intersection of criminal law and immigration law, and debates over American birthright citizenship since the passage of the 14th Amendment. So needless to say, we've got a lot of contemporary and important topics to talk about. Prior to joining the faculty at Northeastern, Professor Rosenbloom was a human rights fellow at the Center for Human Rights and International Justice at Boston College, where she served as the supervising attorney for the center's post-deportation human rights project. The title of her lecture today is The Broken Promise of America's Asylum System. So please welcome, or join me in welcoming Professor Rosenbloom to the stage to talk about this timely, important subject. All right, it's all you.
Thank you. Good morning, everyone. I'm so glad to be here with you today. This is my first time doing anything with Osher, and it's really, wow. You have an amazing program going on here and all over the country, and I'm really glad to discover it and to be on your mailing list now for future events. And so I just want to say a quick thank you to Lisa King, Martha Clark, Peter Paquette, Peter and Susan Brink, and Charlie Whelan for being the moderator, and everyone else who has welcomed me here and made all of this happen today. I was able to tune in last week over the live stream for Professor Edgeworth's wonderful lecture about the Four Freedoms. And I'm going to be, I guess the Four Freedoms were each doled out to people. I got freedom from fear, so that's what I'll be talking about today. If you were at the lecture last week, you heard Professor Edgeworth talk about what freedom from fear meant to President Roosevelt in the Four Freedoms speech. When he spoke of freedom from fear, he was speaking really about war, about preventing war, and about reducing armaments. I'm going to be giving you a slightly different angle on that question. I'm an immigration law scholar, so I will be approaching the question of freedom from fear from an immigration perspective. Here, can we get the next slide, please? As you'll see, refugee and asylum law is an area of the law where fear and freedom from fear is an explicit part of the legal standard. This is the definition of a refugee in US law. It's also pretty much the definition, it's pretty close to the way it's worded in international law as well. So a refugee is any person who is outside the country of their nationality, unable and unwilling to return to that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. And you'll notice it says persecution or a well-founded fear of persecution, but in fact, it's actually very rare for someone to be granted protection just on the basis of something that happened in the past. Almost everyone who receives any protection under this statute, it's because they've shown a fear of future persecution. So that's really what this area is all about, is freedom from fear. And the United States has never entirely lived up to that promise, but right now we're seeing something even different. We're seeing the United States not only fail to protect people from harm that they are fleeing in their home countries, we are seeing the United States starting to put people at risk of harm in other countries that they would never have set foot in if the United States hadn't put them there. So we're seeing a real reversal of this system in a way that I think even those of us who are kind of critics of the weaknesses of this system could never have imagined. So I will be talking about that, but before I do, I want to talk to you about where this system came from, what were the goals, what have been some of the shortcomings from the beginning, and the ways it's been chipped away at over the years, and then obviously what's going on today. So I'll just start with a bit of very famous dialogue from The Sun Also Rises by Ernest Hemingway. There's two characters. You've probably heard this in one form or another. One of them, Bill, says to the other, "How did you go bankrupt?" And the other character, Mike, says, "Two ways, gradually and then suddenly." Okay, so that, if you want the three-word version of the talk I'm about to give you about how the promise of America's asylum system was broken, that's essentially it. Gradually and then suddenly. The suddenly part we're seeing play out now. You're seeing it on the news every day. And I will be talking about that. But before that, I want to talk about that gradually part and what's happened over the years and how we got to this moment. So let's see. Next slide, please. And And if you were at last week's lecture, this is the St. Louis, which actually was talked about then too. So this is really, this area of law dates from the same kind of era, the same moment of time when the Four Freedoms speech was made. So this is actually 1939. This is the SS St. Louis. It sailed from Hamburg in May of 1939, carrying 937 passengers, mostly Jewish refugees from the Nazis. Most of them were hoping to get to the United States, couldn't get visas to come to the United States. That was also part of the lecture last week, the anti-Semitism in the State Department and the unwillingness to bring Jewish refugees from the Nazis. And so they were sailing to Cuba, and but when the ship got there, it was not allowed to dock, and the captain made desperate calls to come to the United States, and famously the ship was close enough to Miami that they could see the lights of the city, but they were not allowed to come ashore, and the ship returned to Hamburg, and some of those people on board were able to get refuge in other countries, but several hundred of those people died in the Holocaust. And so it was it has gone down as a symbol of the failure of our immigration system to have any, at that point it had no provisions for refugees at all, and it was, it got a lot of attention, when the ship was there, it got a lot of attention, and then particularly after the war, when the full horror of the Holocaust became clear to everyone, it has remained this haunting symbol of those failures. And so you get the first laws, the first US statutes in this area date from right after the end of World War II. Can we have the, oh, actually, no, this is good. So in this era, this is the initial, we can call this stage one. So from 1948 is the first statute, and up until about 1968, it's kind of a piecemeal approach. There's a bunch of different statutes. Meanwhile, there's an international convention in 1951, the Convention on Refugees. The United States does not sign on to that initially. It does its own thing, has a bunch of different statutes, and initially directed at displaced people after the war, but it quickly takes on a kind of a Cold War flavor. So there's something called parole, for example. Parole, which is not what parole is in the criminal system. Parole is a way for the government, the federal government, to allow someone to come into the country without giving them a visa. It sort of says, you've got permission to come in. We're not really clear what your status will be. Usually, sometimes it's a temporary thing. People can be paroled in for medical care or something. But when it's with refugees, it's usually in anticipation that they will then get some other status. They will apply for some status once they get here. So parole was one of those early tools that was used first to bring in Hungarian refugees, and then Cuban refugees, later Southeast Asians, Chinese refugees. So in this era, you have mostly what is happening is giving relief to people who are fleeing from communist regimes. It's got as I said, a kind of a Cold War flavor, and it's very shaped by US foreign policy, and is discretionary. It's sort of, here's this power the government has. It's not saying anyone has a particular right to anything. It's just saying if the government would like to let people in, here's a mechanism to do so. And then there is something called conditional entry, which is bringing people from other countries to the United States, also with that same flavor, mostly people from communist countries. And then withholding of deportation, which I want to spend a moment on because that will be a thread that runs through this. So what withholding of deportation says here, it's right at the bottom, maybe it's a little hard to see, that the Attorney General, that was who was, the immigration agency was under the Attorney General at the time. So the immigration agency may withhold deportation to any country in which, in his opinion, the non-citizen would be subject to persecution on account of race, religion, or political opinion. So that's where you get that first sort of kernel of what becomes the standard I started with, which is now a little bit broader. That withholding starts earlier, but that language goes in 1965. But it's discretionary. Again, it's not a right that anyone has. It just says if the immigration agency wants to not deport someone on this basis, it can do so. Next slide, please. So we enter a new phase here in 1968, and I think we could call this a phase of expansion between 1968 and 1980. And what happens in 1968 is that the United States signs on to the Refugee Convention. It signs something called the Protocol, which is an updated version of the 1951 Convention. After doing its own thing, which the United States, when it comes to international law, the United States generally likes to do its own thing. It doesn't like to be bound by international law, but in this case, it signed on. And there's a couple of significant things about this. One is that this is mandatory. So as I was saying before, it was all discretionary, but this says here, the convention says that no state that has signed this convention shall expel or return a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened. So that's a really big change. And then the other change is that there's now 5 grounds instead of 3. So what's added to that is nationality and membership of a particular social group, which is a kind of an open-ended one that has now allowed different kinds of claims to come in. In that early phase, in the 50s, 60s, even 70s, you're mostly seeing political opinion, people, again, fleeing communist regimes and claiming that they are being persecuted on account of their political opinion. So this opens it up, and it makes it mandatory. And so after, next slide, please. So here's what this is kind of the current structure of our laws right now. There are 3 components to our refugee and asylum system. There's an overseas refugee resettlement program that is something where it's people who are already not in they've already fled a particular country. They're in a third country. Sometimes, for example, they might be in a refugee camp somewhere. And they are given visas. They're given permission to come to the United States. And that is a path to lawful permanent residence status, a path ultimately to citizenship, and it's whole families that are allowed to come. That remains highly discretionary. So the president and the State Department make a plan every year. They present it to Congress, and they say, this is how many people we want to bring. These are the categories, the priorities. So this is kind of a throwback, in a sense, to that early phase. American foreign policy is sort of front and center there. There's millions of refugees all over the world, and there's 20,000, 100,000, up to 200,000 at its height of people being chosen. And for a long time, the United States had the biggest refugee resettlement program in the world. We are now not, that has changed. It changed in the first Trump administration, and it's changing back now. But then you have asylum and you have withholding. And so asylum, that standard I started with, the definition of a refugee, someone who has a well-founded fear of persecution on account of any of the 5 grounds. What the asylum statute says is that anyone who makes it to the US, to a border or to within the US, who can apply for asylum on a showing that what they're arguing is that they meet the definition of a refugee. But let's look at this, sorry, we'll have to wait to the next slide to look at the exact language of it. But, and then withholding, which is, which you're already familiar with, right? The withholding statute stays in there. Now, let's, here, and I'll talk in a minute about, there's a couple of later additions to this. There's temporary protected status and relief under the Convention Against Torture. I'll mention those in a few minutes. Can we have the next slide, please? So this is the text of the asylum statute. Anyone who is physically present in the United States or who arrives at the United States, it's very clear whether they come in an official border crossing or they cross the border anywhere else. It is very, very clear anyone should be allowed to apply for asylum. And then you have withholding, and they're quite similar, right? So they have the same 5 grounds. They're both about persecution. They're both largely forward-looking. You have to show that you would be persecuted. You might be wondering why have both? When they adopted this asylum standard and when the United States signed on to the International Convention, why did withholding stick around? If you're wondering that, it's a good question because it shouldn't have, really. Most countries that adopt the convention don't have these 2 systems. The United States was kind of stingy when it signed on to the convention. What it said was, the only thing we have to do under this law is not return someone to a place where there is a more likely than not chance that they would be persecuted. For other people, the people who just have a well-founded fear, maybe they can't show that it's more likely than not. They just have a fear, right? They're covered under the convention, but the United States has always interpreted asylum to be discretionary, to be something that the government can do, but it doesn't have to, which means it sets up a 2-part system. And so basically, asylum is kind of the gold standard. It's what people would want to get. It is a path to citizenship, and it allows people to bring their spouse and their children. But there's this other thing hanging around, and it's been in the news a lot lately. I'll come back to it now. It's kind of, it's got a new relevance because the Trump administration is attacking it so much, is this thing called withholding. Because withholding is not as good. What withholding says is someone has a removal order. They're gonna, they could be deported somewhere, but they can't be deported to that one country where they might be persecuted. They've still got that removal order hanging over their head. Now, traditionally, that hasn't been a big problem. People have spent many years in that status, but it's one of those points of vulnerability that I'll be speaking about later. So I just want you to note that that's kind of in there, and it's really under attack these days. So this is our basic structure, and there are some weaknesses. Next slide, please. To this, there's some built-in limits to this. One of the limits is we refer to the nexus requirement. So this system has never been for protecting everybody from all forms of harm. It just isn't. It is for protecting people who have a well-founded fear of persecution on account of 5 grounds. And that covers a lot of people. Millions of people have been protected under these laws, but it really doesn't protect everyone. What if, there have been questions, but a lot of litigation, particularly in the 90s and since then, as new claims have come up. So some of them have been relatively easy. So there were claims based on sexual orientation or gender identity in the 90s. And at first, the agency didn't want to grant those. And there were arguments made that counts as a particular social group, right? That is one of the grounds. And for the most part, that's been pretty successful. But there are other questions that come up as well. So, gender-based claims. Well, if you can really show that people are being targeted based on their gender, some group is going after people based on their gender, sure, that's fine. But sometimes a lot of gender-based violence, for example, happens in the home. So what if it isn't that someone's being targeted because they're part of some group? They are simply being subjected to, they're one person being subjected to violence by another person who they're in a relationship with. That has been a struggle. So the case law has gone back and forth over the years about that. There have been years where domestic violence cases have been recognized as being a part of this, as being protected, and there are grounds for protection, and there have been years when, particularly, for example, during the first Trump administration, where the case law swung back the other way. But there's other questions that even that raise harder issues. Like, what if someone is fleeing a really dangerous situation? There is rampant civil strife, political violence. There were, thousands of people who fled Haiti, for example, for many years, in the 80s, 90s, and there's a version of that going on today, but there was a coup in Haiti in 1991, really horrific violence in the wake of that. They're absolutely fleeing political violence. But what if they can't show that they're being targeted, right? That they are being targeted on the basis of their race or religion or political opinion or some other ground? It's just really dangerous. And they could establish absolutely that they have a fear of persecution. They could establish maybe that they have a fear of being killed. But that's not enough unless you can connect it to one of these grounds. So that's been a major shortcoming. And even you could think about environmental disaster as well, right? Climate change, extreme poverty, famine. There are all kinds of really life-threatening conditions that people flee. And this system has never been fully set up to protect all of them. And so one of the other forms of relief that has come up, that was added on later, something called temporary protected status, which to some extent addresses that. An entire country will be designated for temporary protected status. Maybe there's been an earthquake there. Maybe there's a civil war going on. Those kinds of situations where people can't show that they are being targeted, but there's a recognition that that country is too dangerous to go back to. So an entire country will be designated for temporary protected status. So that helps, but it is temporary. So it's not as secure a status. And then the other thing is the Convention Against Torture, which the United States signs onto in the 1990s. And that is a bar on, it absolutely fully prevents countries from returning anyone to a country where they face torture, where they would face torture. And it does not require showing that it would be targeted. It is just an absolute prohibition of sending someone back to a place where they would be tortured. It's very hard to get. There's a very high bar for getting that relief, but for some people who can't show that kind of connection to a protected ground, it can be helpful. And then the other limitation is that there have been, it sort of slowly ramped up in the 80s and 90s, but there have been criminal bars, or there's all kinds of limitations. So for someone who's found to be a persecutor of others, which sounds really bad, but sometimes that turns out to be someone who was persecuted themselves and was forced, to, as sort of part of that persecution, forced to do something to someone else. There's a lot of complicated cases out there. Anyway, persecutor of others, someone who has a criminal, who's committed certain kinds of criminal acts, including, for example, sometimes it includes things that are done kind of as activists, like somebody, they break windows or burn up a bus or something like that, that's part of some civil strife of some sort. So it can include all kinds of things. And it can also include convictions that happen in the United States, and this is an area that has gotten broader and broader. So there's sort of two sets of limitations on this. And next slide, please. So this system gets expanded between 1968 and 1980. And then, really basically since then, since it reaches its full breadth, there have been attempts to narrow it and chip away at it. And this is where, the gradually part of the gradually and then suddenly. So just briefly to talk about a few of these ways in which it has been chipped away at. So one is deterrence and interdiction, which means basically keeping people from getting to the United States. Interdiction is intercepting people. So that photo is a Coast Guard ship intercepting Haitian migrants, asylum seekers coming in boats from Haiti. Now remember that the language of the withholding statute, which, after 1980, this is mandatory. No state shall return anyone to a territory where their life or freedom would be threatened on account of any of the grounds. The Coast Guard, in the 80s, there's all these people fleeing Haiti. They start picking people up in international waters, and initially, the Coast Guard is supposedly screening them on board their ships for asylum claims. But out of like 23,000 people, I think it was, that were picked up, 28 ever were found to have relief. And it was very well documented. People were fleeing horrific violence. So it essentially was not any meaningful screening. And people were being just sent back to Haiti. After 1992, it becomes a formal policy to not even screen people. It's just automatic. And the Coast Guard is picking up Haitian asylum seekers in international waters and delivering them back to violence in Haiti. This seems like something that is in clear violation of both our domestic laws, right, which got updated to reflect that language that may not, like the Attorney General shall not return somebody, and international law. But it goes to the Supreme Court, and the lower courts agree that this is not okay. Goes to the Supreme Court, and a divided Supreme Court says it's actually okay. Why is it okay? It's okay because none of it happened in the United States. If these people had made it to the United States, they would have this protection. They would be covered by this law. But since they hadn't come yet, our statutes didn't kick in, and international law, our courts don't generally like to apply international law unless it's in a statute. And so it's this awful loophole. And what it does is it kind of, it suggests this route, which we're now seeing now, of trying to keep people from coming. You see this all over the world at this point. So Australia intercepts people in international waters and takes them to detention centers that aren't in Australia. We give money to Mexico to intercept Central American asylum seekers before they can make it to our border. Europe does this with Turkey. I mean, this is a kind of this has been the name of the game at this point for quite a while, to try to keep asylum seekers from coming. Another thing that happens is something called expedited removal goes into our statutes. It's also one of those things that's now in the news a lot. So expedited removal comes in 1996. Before that, so let's say somebody showed up in 1990. If they actually are able to make it to our shores or to our land borders or to an airport, if they don't have the papers to come in, right, and they say they want to apply for asylum, they would end up in front of an immigration judge. Everybody in that situation would just have a hearing, a regular hearing, and they could seek whatever form of relief they thought they were eligible for. After 1996, a lot of those people never get to see a judge. They are basically put into a fast-track system where some officer orders them removed. If they express a fear of returning, they are supposed to then be channeled into, they get a screening by an asylum officer to see if they have what's called a credible fear of asylum, and if they do, credible fear of persecution. If they do, they're supposed to be channeled into the regular proceedings. Sometimes that works. A lot of times it doesn't. People, you know, it's not a perfect system, and so a lot of claims that have merit just never make it to the immigration judges. So that's another way this system has been whittled down. Time limits. Also in 1996, there's a 1-year time limit that goes in for applying for asylum. So if someone's at the border, they've just come in, fine, but sometimes people you know, are here for a while, and then they, when they get, used to be when they would get apprehended, then they would be going before a judge and they could seek asylum. Now, most of those people, and there's some exceptions in certain situations, but mostly people are filtered, they're put into this, what we'd call withholding only. So all they can get is this, they can apply for withholding, which, as I mentioned, is not as good. It's more vulnerable. It doesn't give you a path to citizenship. It also doesn't allow you to bring your family members in. So each person in the family would have to individually apply for that. And it's also harder to get. You have to show not just a well-founded fear, but this higher standard that it is more likely than not that you would be persecuted. Let's see. And then the criminal bars, as I mentioned, they've been broadened so far that they're kind of beyond recognition. Some convictions you might think were very minor, including in some cases like a shoplifting conviction or something, or minor drug convictions can in certain circumstances trigger this bar. And so that also puts a lot of people in withholding only cases. And then the terrorism bar, which has also grown so broad that it is beyond recognition, and includes, for example, it includes material support for terrorism, right? So what does that mean? Well, it might mean that some people, you know, some insurgent group comes and takes over someone's village and essentially takes money at gunpoint, you know, takes money from them, makes, there was a famous case of a woman who was kidnapped, who was forced to do laundry and cook for this group. And there are some waivers available, but there's no exception for even small amounts. You put some money in a can for a bake sale for some, you think it's a charity, it turns out they've got a wing that's been accused of terrorism, so there's no, you know, people can be caught for very small amounts of support or even for coerced support. So the terrorism grounds are very, very broad. So this all kind of brings us up to the relatively recent past, let's say to 2016. This is what the world looks like, you know, before Trump comes in. There's a system. It is protecting a lot of people, but it has been incomplete from the start, and it has been whittled down considerably by all of these changes. And then, of course, next slide, please. You get the first Trump administration, which there's a lot. This is not an exhaustive list. That is a picture you might remember of those kids in cages, children who were being held. There was a zero tolerance policy which separated children from their parents, and this was, you can see the roots of a lot of these things in the period I was just talking about. So deterrence, right? This was pitched as how to get people to stop coming and applying for asylum, rip their kids out of their arms, and don't keep a list, right? The government did not keep a list to be able to reunite those kids. There are kids who still haven't been reunited with their parents. So this was one of those moments, I think, that when it really hit me. There's so many problems with the immigration system. Those of us who study it, we're used to talking about how people's rights are violated, how people don't have the same kind of due process rights they have in some other areas, the flaws with the system. But even people who'd been doing this a lot longer than I had, who had seen really terrible things over the years, were really speechless at this. It was something that you just couldn't have imagined would happen, taking thousands of children from their parents. There was the Muslim ban, which was challenged a couple times in court, and then it was revised. So it banned people coming from a number of different countries, mostly Muslim countries. There was I'm not going to go into detail on all of these, but these were all ways to kind of either keep people from being able to apply for asylum, or have their cases denied once they applied. There were also changes to the case law. I mentioned that domestic violence and some other issues. The immigration courts are actually under the Department of Justice, so they're under the Attorney General. They're not independent courts. They're part of the executive branch, and so the Attorney General actually can change the decisions of the Board of Immigration Appeals. These sometimes go to federal courts, so the courts can change it back. But if the Attorney General, if you get a new Attorney General in who wants to do something different, they can change the case law about a lot of things. And so it's been a little dizzying between from Obama to Trump to Biden. Like, every time I teach my refugee and asylum law course or my immigration law course, it's kind of, it's changed. It just changes every few years because these are issues like labor law issues, like some other issues where there's executive agencies that are deciding things. The pendulum can swing back and forth. So I think the big picture here, this was very different. So the family separation policy was stopped. It was stopped by the courts, and then eventually it was also, Trump actually backed down from it and issued an executive order backing down from it, and which is rare in this situation. But I think that in general, the way that the first Trump administration played out versus the way it's playing out now, a lot of really awful things happened. The pace was a little slower, and it was a little bit easier to kind of to challenge. A lot of these things got blocked. One that didn't get blocked that I want to note, because I think it's significant now, is Title 42, which is actually a public health provision. It's not part of the immigration laws. Trump basically shut down the border during COVID under this provision that allows the government to kind of block entry of people who are coming from places where there's a contagious disease. And to me, I think it kind of planted the seed of what we're seeing now, which is that it was a way to avoid immigration law entirely. People were being expelled under Title 42, and it had nothing to do, this whole system that we know that, you have some rules, you have expedited removal, you have this and that, and we've always been complaining about how it's inadequate. Suddenly, you really want that system back, as inadequate as it is, because suddenly the border is actually closed entirely. And so that brings us to where we are today. Can I have the next slide, please? Okay, again, not an exhaustive list. There's so much. We could be here all day. We could be here all week to talk about everything that is going on here. So this is a list of some of the things that are happening right now. And I think what I want to do, rather than go through all of them, is to talk about some big picture issues here. One is that the Trump administration is really well, one is that it hit the ground running this time around. I think the speed, when we were this far into the first Trump administration, most of those things I had listed before hadn't happened yet. And this has just been this barrage of executive orders and changes to policies, everything from birthright citizenship to refugee admissions to parole and TPS, and so I think that there's so much going on. But I think one theme is that the administration is really exploiting every piece of discretion. This is a highly discretionary, I mean, there are pockets of discretion in this. As I said, when we signed on to the Refugee Convention, when the United States signed on to the Torture Convention, it agreed to be bound by these mandatory provisions. But on the whole, there's a lot of discretion that's still in the system. And so anywhere where there's executive discretion, they have pounced. And even, I think, a lot of places where really there shouldn't be, they are arguing that there's discretion, which I think we will see the courts pushing back. We certainly did see that in the first Trump administration on how much discretion there actually is. But anything that could conceivably be seen as discretionary. So for example, refugee admissions. So that overseas refugee resettlement program, as I mentioned, from the start, that has been very discretionary. It's not like, so asylum, anybody who comes here can apply. And there's no numerical limits, there's no foreign policy priorities. Withholding, anyone can apply. There are no priorities, no limits. And, but the overseas program has always been something that the president and the State Department present a plan for, and they say who their priorities are. And so one of the first things that Trump did this time around was to essentially shut that system down entirely. In the first Trump administration, there was a huge reduction in the number of people who were brought in on the refugee resettlement program. This time around, it was absolutely shut down. There's been, as far as I can tell, one exception, which is that white South Africans have been deemed a priority. And you can't make this stuff up. It's like making a mockery of this system, basically. There's all the, and including, I mean, there's people who are in the pipeline who had already been approved. I was just reading a report on queer and trans refugees who had been conditionally approved and were waiting to come to the United States, who are stuck in some awful, like incredibly dangerous situations. You know, they just got frozen. They weren't allowed in. And so that is being litigated, and the courts have so far have said that the people who've already been approved need to be allowed in. So I think that there is some pushback there. But the larger question of how many people to allow in and what the priorities are, that really is, there's a lot of discretion there. Another area where the administration has tried to assert this discretion in a very worrisome and novel, unprecedented way has to do with expedited removal, which I mentioned to you that it went in 1996 as this system that people who, usually it's people who are at the border who, if they don't have the right papers to come in, they're put in this fast track system. They're diverted. They don't get a regular hearing unless they show that they have a fear of persecution. The way the law is worded, it's broader than that. It can actually be applied to anyone who's been here less than 2 years. It's generally been applied to people who've been here less than 14 days. So it was supposed to be people sort of at the border or close to the border, recently arrived. And so the Trump administration has said, first of all, that they're enforcing it to the full extent, but not only that, they're doing something that no one has ever done. You might have seen the news reports about these masked ICE officers who are showing up at people's immigration court hearings. Right? These are people who are showing up for their hearings. They have been, most of those are people who were granted permission to come in. They were mostly through parole, actually. So parole, I mentioned, that's one of those early tools that's been in the statute forever. It came in that first phase. The Biden administration paroled in a lot of people. It had a special program for Cubans, Haitians, Venezuelans, and Nicaraguans. It had a program for Ukrainians. It had programs at the border. So the Biden administration version, you know, things got a little better under Biden. They didn't get entirely better. So the border always used to be anybody could come to the border and seek asylum. And those limits, you know, they've been very strong under Trump. They were a little less strong under Biden, but the Biden version of it was this horrible app called CBP-1 that was very difficult to use. People were supposed to apply for an appointment on their phone. It didn't work that well. But, and really, in my opinion, everyone should just have been allowed to come to the border as they always had been. But the people who did use that app, many of them were paroled in. So they were allowed to come in and seek asylum or other protections. So for the most part, these are people who have been given permission to come here, who are showing up at their hearings, who are trying to, you know, who are applying for asylum. And if you'd asked me, I mean, the standard answer 6 months ago, if someone said, can I be deported, can I be removed while my asylum application is pending? The answer has always been no. Like, you know, people are supposed to sort of carry around proof that they have an asylum application and they won't be removed then. But what's happening now is people are showing up for their hearings, and these officers are showing up, and basically the government is asking the judge to dismiss their case. So the judge says, oh, your case is dismissed, and then they get picked up under expedited removal as people, if they haven't been here for 2 years. It's a very, very expansive, I would argue, not entirely legal interpretation of that statute. So that's working its way through the courts. But that's the kind of the hook for it. If you were wondering, how could they possibly be coming and arresting people at their hearings? The way they are doing that is the proceeding before the immigration judge is being dismissed. And so suddenly, and their parole, I should also say, is being revoked. That's another thing so Trump has revoked, the administration has revoked parole for hundreds of thousands of people. It has also it has ended TPS. Remember, I talked about temporary protected status for Haitians, Venezuelans, a number of different countries. Those are also being challenged. And in the first Trump administration, the Trump administration, the first time around, did try to end TPS and didn't succeed. It got tied up in the courts, and it was still tied up in the courts by the time the administration ended. So we'll see what happens with that. But people's permission to be here is being revoked. Their hearings are being dismissed, and they are being snatched up into this system, and they should still be given the opportunity to apply for asylum. All the same rules should apply. But the way things are going now, I think, you know, what we're seeing is people being whisked out of the country very quickly in violation often of court orders. So I think that the through line here is this very broad assertion of discretion to, to decide whether someone should be in regular proceedings, let's say, or expedited removal. And maybe there's a little bit of a hook there in the statute, but I think it's a weak one. And so they're trying to read it as broadly as possible. Then you have another category, which is really just kind of pure lawlessness, in my opinion, essentially trying to just get out of, not even make a pretense of following the rules that are in our immigration laws. So I mentioned Title 42 as this, it planted the seed of, here, can we just bypass the immigration laws entirely and expel people some other way? Now, the version of that we're seeing is the Alien Enemies Act, which is a statute that dates from 1798. It has only been invoked 3 times in this country before: the War of 1812, First World War, Second World War, and and this, certainly it's a shameful history. So if you look at how Japanese immigrants were held as alien enemies under the in the Second World War, and that's a stain on this country's history. So even in wartime, I think there are questions about how much that should be used. But the key point is here, these are not people from countries that the United States is at war with. That's the only way it has been used. It's very clear that it is about when the United States is at war with a nation, with a government, citizens of that country can be held as alien enemies. The sleight of hand here that the Trump administration tried was to take to assert that all of these people from Venezuela were part of a gang, which it seems that they mostly weren't anyway, a Venezuelan gang that's been in the news a lot, and to then say that that was sort of the equivalent of a government, that it was working with the government, which also has not been established, and that there's essentially some kind of war going on. It's just, it's kind of made up, I would say. And there have been several judges who have looked, it's a little mixed. There was a judge who blocked this nationwide. The Supreme Court said, actually, this has to be done locally and through habeas corpus petitions in different courts where people are taken into custody. And so there's now, this is before a bunch of different judges, but several of them so far have said, yeah, you can't use this statute this way. What the Trump administration, you've probably heard about the people who were deported to El Salvador. And I think really, in that case, disappeared is the right word. And I don't use that lightly. That has the history of that word it's a very intense history of people being really taken away. No one knows how to find them. They're tortured. They're killed. So I would not use that for ordinary immigration detention, as bad as I think that sometimes is. But this, I think, really does actually fit the description. There's no record. I mean, nobody. There's been lists pieced together of who was sent down to Secot, that prison in El Salvador, but the government has not provided any information about that. You can't track people through the systems that the government has, and there were several hundred Venezuelans and some others who were part of that group. So the United States is outsourcing this system now, and I think this is really what's being referred to as third country removals is really one of the most chilling parts of what we're seeing now. And we know, so one of the people who this happened to was Kilmar Abrego Garcia, who, as you may have seen in the news, so he was brought back. I'll talk about him a little more in a minute, but this is a prison that the president of El Salvador, who I think has referred to himself as the world's coolest dictator or something, Bukele has created this huge prison. I mean, I don't know if prison is sort of too official a word for it. It's this facility to put all of these people who were gang members or suspected gang members in there. Nobody ever gets out. It is, it's a very awful place. And people are, we now know from what Kilmar Abrego Garcia has testified, people are tortured there. He testified about being beaten. He said they were made to kneel from 9 p.m. to 6 a.m. And if anyone, fell asleep or fell over or whatever, they were beaten. He lost, lots of weight. He was basically starved there. So we don't. And the thing is that there were, several hundred people who were sent there. I mean, there's a 19-year-old, I guess he's 20 now, a Venezuelan asylum seeker who was paroled in, had a pending asylum claim, and was living with his sisters in Texas. There's endless stories about these people who just kind of got snatched out of their lives and just basically taken away without any notice, without any chance to ask for any kind of protection. And so remember here, and there's also the South, people being sent to South Sudan. Now, South Sudan has a level 4 warning. If you're a U.S. citizen, you're looking at the State Department, you're thinking about going to South Sudan, you probably aren't, but if you were thinking about going to South Sudan, if you check the travel warning, it says make a will before you leave. I mean, it's basically saying you're gonna be killed there, and so there's the administration is trying to make these deals with kind of some of the most unstable and violent places on Earth, and it is saying it is asserting the right to send people to third countries, and so this gets me back to withholding. Remember that thread that's kind of run through this, that withholding, someone who gets granted withholding has an order saying they can't be returned to that country. It doesn't say they can't be returned to other countries. Now, I think, and several dissenting members of the Supreme Court agree with me, that there is no basis in the law to just send someone anywhere. Usually it's sort of, they get sent to the country they came directly from, or the country they're a citizen of, or a country they've habitually resided in, some country that they have a connection to. So there can sometimes be or a country they designate. So there is room in the statute to decide where to send someone to. But this idea that someone can be sent anywhere and imprisoned anywhere in the world or subject to extreme harm, I remember we have an obligation under the Convention Against Torture to not send anyone. There's an absolute bar on sending people to countries where they might be tortured, right? So here's Kilmar Abrego Garcia. He fled violence in El Salvador. He came here as an unaccompanied 16-year-old. He got across the border when he was 16. He did not get apprehended then. He got apprehended several years later, and he was granted withholding based on his fear of going back to El Salvador. So the fact that they sent him to El Salvador, it was in direct conflict with that order. But I think what they want to do now, they brought him back because there was so much outcry. They brought him back supposedly to prosecute him, but they don't really have a criminal case against him. And it seems pretty clear that they want to he's now, he's being held, but that he's being held in criminal custody, that as soon as they get him back in immigration custody, it seems like they want to send him to South Sudan or someplace else, and say, oh, well, you were granted withholding to this one place and not to another. So this is a really, really troubling part of what's going on. I want to just close with a couple of, can we get the next slide, please? Okay, so what do we do about all of this? I would bet that there's a range of opinions in this audience and on the online audience about what an optimal immigration policy would be. What kinds of visas should we have? How many visas should we have? reasonable people can disagree about those questions. I want to suggest to you that the things I'm talking about transcend that. I think that whatever your views are about what a perfect immigration system would be, we're in totally different territory here, and that all people of conscience should be deeply disturbed by what is going on. And this is really about fundamental rights, about due process rights to go before a judge and get to make your claim, about guaranteed international rights to not, to be free from torture and persecution. And I think what I'd like to leave you with is, if you are upset about this, which I hope that you are, a couple of points. So one is to be mindful of making distinctions when talking about these issues between good immigrants and bad immigrants. There is this tendency, particularly to do that along lines of criminal convictions. I keep seeing things written, opinion pieces or statements about Kilmar Abrego Garcia or other people, and they don't, this horrible thing happened, and they don't have a criminal conviction. And I just want to say, I don't care if someone has a criminal conviction or not. This should not happen to anyone. This is completely lawless and should not happen to anyone. And there has been a real tendency in immigration law to divide people based on their involvement with the criminal justice system, which I think, honestly, we should be critical about that in all areas, given the level of over-policing and given the racialization of policing. I think that it's always good to be kind of critical of using that as your metric, but particularly on these issues, I would love to see people kind of just speak out about this plain and simple, without trying to figure out if someone's a perfect person and deserves these rights. And then I think the other thing is just don't underestimate how important it is to speak out about these issues. Trump has backed down. He backed down on family separation. And yes, there's always litigation, that matters, but that's not what got him to issue an executive order undoing the family separation policy. It was the revulsion that people expressed. It crossed a line. We are in one of those moments. This is really crossing a line. So calling your congressional representatives, even the ones who are sympathetic, they should be there. They should be traveling to El Salvador to meet with people. They should be really going to detention centers out there. This stuff has to stay on the front page of the newspaper every day. It's the only way. The litigation is very important, but it's not going to save us on its own. And just don't underestimate the power of solidarity. It really does matter. There's a lot of ways. Since I'm in New Hampshire, I will just say the ACLU of New Hampshire has been doing amazing work. They are all over a lot of this litigation. There are local immigrant rights networks. There's a lot of ways, even, you don't have to be a lawyer. There's people who are accompanying people to hearings, or there's just so many ways to plug in. Write an op-ed or write a letter to your local community newspaper. Do whatever you can, because this is, it needs to be stopped, and it is such a, these actions are really, they're the hallmark of a totalitarian regime. Like, this affects all of us. Trump has said he wants to send US citizens to this prison in El Salvador. And, this is people being taken away by masked men with guns and whisked somewhere in violation of some court order. This is the kind of thing that these laws, our refugee and asylum laws, are designed to protect people from when they happen in other countries. And now we are engaging in those acts ourselves. So thank you, and I really look forward to hearing all of your questions.
Thank you so much. There's a lot of meat left on that bone. And in that spirit, what we're going to do is we're going to take a break until exactly 10:30 to give you a round number. Now, as soon as possible, if you have questions online, please drop them in the chat. Or if you're here, put them in the basket right in front of the stage here or in the back. And what we're going to do over the next 20 minutes is we're going to take those questions and we're going to shuffle them around and see what people want to talk about. We'll be back at 10:30 for a Q&A with Rachel, which I think will be fantastic. So please ask your questions and we'll see you at 10:30. Thank you, everybody. We're going to get started with the Q&A. We have a surfeit of great questions, many of which overlapped, which will be nice. So this is our chance to go a little deeper and have a discussion. But for all of you who submitted questions online and in person, we have lots of great cards. So I'm going to start, if everybody could settle in and keep your cell phones off, with a legal question, which you referred repeatedly to the courts and the legal process and judges. And so this question comes from Graham in Rhode Island, which is, why is it taking the courts so long to decide on whether what's happening is within the law and the Constitution?
That's a great question. So the answer is, in some ways, it is and it isn't. So the whole process takes a long time. You have a district court judge. Someone will run into court and seek a temporary restraining order and say, you know, please block this right away. And then a few days later, they'll come in with a little more time and with some briefs and ask for a preliminary injunction. And at that point, the judge might block something, and but then it's going to be appealed to the Court of Appeals, which is a slow process, and you get briefs on both sides, you get oral arguments, you have to wait for the decision, and then eventually it might go to the Supreme Court, which also is going to add a bunch of time to it. But so here's the thing. A lot of times it's actually quite quick to get something blocked. So what courts often do is they say, this seems like it's not okay, and like someone's going to be really harmed if we let this go into effect. So we're going to block it temporarily while this case is going up through the courts. And that's what has happened on almost all of these issues so far. You know, that it happened on pretty much everything on that list, right? So judges said, no, this is not okay. And the problem, so then what the government does, though, is it asks for a stay. So what that means, the whole question is, it's going to take a couple years, let's say, for something to be litigated. So what's going to happen in the meantime? The government comes in and says, we want to be able to put this into effect while you're making your decisions. And the lawyers for the people who are going to be affected, going to be deported, all these terrible things that are going to happen, they're coming in and saying, no, you need to keep this on hold while that process is going on. So that initial decision is quick, but it makes all the difference. If you've got this longer process going on, if it gets blocked, if you're the person challenging it, you don't mind that it goes on for 3 years or 4 years. Maybe it even goes on until the next administration. You're okay with it taking a long time as long as it's blocked in the meantime. The problem is when it's not blocked. And so this is a really major issue we are running into. Because we have a different Supreme Court than we had during the first Trump administration. And so I think the hallmark, generally, when people challenge a government action, often under the Administrative Procedure Act, sometimes constitutional grounds, historically, the government usually wins. That's just sort of overall, because there's a kind of a presumption of what's called a presumption of regularity, that the government's doing things well. It's pretty hard sometimes to show. Like sometimes there's discretionary decisions, the government has some leeway. The hallmark of the first Trump administration, and now the second, is that they're losing all of these cases because what they're doing is so far outside of the law. There's a lot of wiggle room for the government, but there isn't enough wiggle room to just completely flout the law. And so the Trump administration lost a lot of cases the first time around. This time around, I saw a fascinating chart that someone put together, I think a political scientist. It showed the wins and the losses. So at the trial courts, in the district courts, so far the Trump administration has lost 94% of the time. So And so that's not a partisan thing, right? That's not judges elected by Democrats. That's You can't win, you can't lose 94% of the time without getting people from both sides. And there have been some like Reagan appointed judges, for example, who have said things like, I have never seen anything this unconstitutional in my life. Like some of these are really, really clear cut. So that's great. The problem is something called the shadow docket. So what happens is that usually this stays at the Court of Appeals. The government will go to the court and say, can you, don't let this thing be blocked while you're making your decision. Let us carry out this policy while you're figuring it out. Well, the courts of appeals generally have refused to lift the orders, they've let it stay blocked. The government is going to the Supreme Court on these emergency motions, which really even shouldn't be heard. Like, let me just give you a really stark example. Birthright citizenship. Okay, there's been a rule of birthright citizenship that has been in place since 1868, since the passage of the 14th Amendment, and has been subject, there's been a Supreme Court case on point for 127 years. It's very settled. We know who's a birthright citizen and who isn't. Trump comes in, he tries to change the rules on birthright citizenship. It remains to be seen whether he'll get away with that. I don't think he should, but whatever. There's an argument. The government will make its argument. But what happens in the meantime? So they went to the Supreme Court and said, it's an emergency. You have to let us put this into place. It's not an emergency to keep doing the same thing you've been doing for 127 years. Like that usually wouldn't count as an emergency. The court is listening is allowing those motions much more than it normally would. I think it was Justice Sotomayor who said in a dissent recently, everybody else has to follow the rules, but the administration has the Supreme Court on speed dial. Those are her words. And it really is. They go to the Supreme Court, and the thing about it is when the Supreme Court decides a case, finally, it takes a couple years, the case goes up, there'll probably be 100 pages of opinions and dissents and concurrences. There'll be lots of explanation. Here's why we think this side should win or that side should win. These emergency motions don't get decisions. They've been getting dissents because some people are really upset by but you'll just be a sort of an unsigned order that just says, so the third country, one of the most egregious ones I mentioned was the people being sent to South Sudan, these third country removals. So a judge said, you can't do this, this is blocked. And it went up to the Supreme Court, and the Supreme Court isn't deciding the matter yet, but it basically said, we're not blocking it while it's going through the courts. And they didn't say why. I mean, this is going so far outside what the law has been, you would expect them to give you an explanation, but they're not. So this is the problem, this is the position we're in. The courts are blocking these very quickly. Some of those orders will stay in place, but a lot of them are now being put on hold by the Supreme Court. And so we are going to have to wait for this litigation to play out, and a lot of people will be harmed in the process.
Small follow-up footnote. New Hampshire is figuring large in this legal battle. Just like Daniel Webster in the Dartmouth College case, we're a small state. So why is New Hampshire playing an outsized impact?
Yeah, New Hampshire has. I think, whenever you have a case that you can bring anywhere in the country, it's affecting people everywhere. You think about what courts are strategic to bring them in, and like the birthright citizenship case, for example, I mean, there were cases brought all over the country, but one of the first was New Hampshire, so it got a lot of play for that. And given just the dynamics of the judges, what you see frequently, for example, is again, when like the Attorney General of Texas was filing a lot of cases against the Biden administration, there was litigation that actually stopped a lot of Biden policies. The kind of classic move was to run into court in a particular district in Texas where there's very few judges and they're very reliably conservative. So that game gets played on both sides. I think we will see less of it a little bit because the Supreme Court has just barred the district court judges from issuing nationwide injunctions. Generally, courts don't issue nationwide injunctions. They just say something for the jurisdiction of, within their jurisdiction. This seems illegal, but somebody else could come to a different decision somewhere else, and eventually it filters up to the Supreme Court. The only time you get nationwide injunctions is if there really seems to be a strong reason. So, for example, birthright citizenship, well, you can't just block it in New Hampshire. I mean, because what if someone's born in some other state and is not considered a U.S. citizen, and then they, the parents, the family moves to New Hampshire, and it affects what benefits someone gets. So, the courts basically said, oh, well, we're blocking this nationwide. That went up to the Supreme Court. The Supreme Court decided you can't do that. Now, of course, there had been many nationwide injunctions against Biden policies. The court never intervened then. It now intervened on the side of the, on the side of the Trump administration and said you can't do that. That's why it came back. So New Hampshire, the same judge in New Hampshire just it was a do-over. Now it's a class action. So there are other ways to do this, but I think. So sometimes you'll see class actions, but class actions are kind of complicated, and so you might see more of litigation all over the country.
We haven't talked about politics or Congress, both of which are lurking as powerful forces in the background. So we had a question. One of the reasons Trump was elected was because of immigration. Isn't this what the majority of people voted for?
Well, that is also a great question. I mean, I think this is one of the hardest questions we face, is what do voters actually want? And I do think immigration did poll very well for Trump during the election. There's no question that was part of it. But what I'm struck by is all the comments I've seen recently. There's certainly some people who are cheering this on. I mean, there are pockets of very, very strong anti-immigrant sentiment. I don't want to, gloss over that. But I'm struck by there's so many people being picked up in different communities now, and you see on the news or you read in the newspaper, there's interviews with their communities. So there was a young man in Massachusetts, I think 18-year-old high school senior, who was grabbed on his way to volleyball practice and detained, and he eventually got out of detention. He's back in his community, and there's these pictures of him kind of being embraced by all his friends. I think he's Brazilian, and I saw an interview with, I think it was a close family friend of his, someone from his community, someone who's also Brazilian, who was talking about how terrible it was, that why did this young man, this very promising sort of top student, whatever, member of this community, it's so senseless, how could he have been grabbed? And it came out in the process of it that the man who was speaking had voted for Trump. And what he said was, he said he was going to go get the criminals. And this is what I meant about that discourse of being careful about dividing things. Lots of people voted for some idea that there were really bad, dangerous people out there, and that Trump was going to go get the bad, dangerous people. And that's not what's happening. And so I think people are seeing that, and we live in an age where there's a lot of misinformation out there, and people get their news from memes, and we all live in bubbles, and there's just the social media. This is the problem of our times, is that people aren't necessarily voting based on accurate information. So to some extent, that vote was people who are really full on in support of what is being done now. And to some extent, it was people who had some idea about what it was going to be that is really very different from what it is. And you're already seeing the polling data shifting very. So it's all of the Trump policies are polling very badly. Like they're all under 50%. The immigration has been a little higher than some of the others, but still unpopular. But I just saw a recent poll about, it was just a sort of general poll, do you think there should be more immigration or less immigration? You know, is immigration a good thing or not? And it has flipped, it has really switched. And this is something you see a lot. So like during the first Trump administration, there was a groundswell of support for immigrants, and there were people who really changed their mind. And when they saw the kind of, if you work with immigrants or you're in an immigrant community, you know how harsh the immigration laws are. If you're insulated from that, we go about our lives, we don't understand these, you know, this whole system. When you get a glimpse of it, you see it, it does change people's minds. So I think that pendulum kind of swings back and forth.
So still on the political, if you could go back in time and advise people who didn't want to get to this place, what they might have done differently, either substantively, politically, performatively, you know, were mistakes made or opportunities missed that might have made this a less salient issue?
That's right there. That's the big question, and I'm not a political consultant, so that's why I sit there and do my legal work. I'm not sure that I have the magical answer to that. I think, I think one thing I will say is that Democrats have really not known how to deal with immigration. Like Republicans have just been kind of anti-immigration for a long time. And Democrats have kind of spoken out of both sides of their mouth. And in some ways, I think what you need is a more full-throated defense of immigration. And so, you know, this sort of, like for many years, the conventional wisdom was that if you were going to get immigration reform in Congress, that if you were a Democrat, you needed to be tough on immigration. So I don't know if you remember, but activists nicknamed Obama the deporter-in-chief. Deportations actually went up under Obama, and there was this theory that kind of if you look tough on immigration, then you kind of can win some concessions. I don't think that worked out that well. I think that, and you know, if you look at sort of like, I mean, you can't generalize this to the rest of the country necessarily, but like Zoran Mondani's recent win in New York, sometimes there's something to be said for just full on being your authentic self and sticking up for the values as opposed to kind of trying to go both sides and confusing everybody.
There were a number of questions, including me, after I heard you talk about comprehensive immigration reform. And to refresh, we being Congress, but the United States, have gotten so close, or would appear to be so close. So there was the McCain-Kennedy bill in the Senate, and you think, if you get McCain and Kennedy on board, and this was comprehensive, so it was H-1B visas, it was border security, it was employment verification, and the theory was, it's bipartisan, if it looks at all these pieces, maybe we can get across the finish line, and then not long after that, you have Jeb Bush and Mac McLarty, who you may remember as Clinton's first chief of staff, and then more recently in the Senate, you had one that I think ostensibly was sabotaged by Trump. So given that we've gotten so close, and there does seem to be bipartisan support for fixing the whole system, what keeps going wrong, and is there hope for resurrecting it at some point in the future?
Well, I always have hope. I mean, I feel like you have to have, right? Hope is a discipline. I do.
If you lose hope, we have questions later about asylum in Canada. We'll come back to that.
I don't give up hope, and I do think that the excesses of the Trump administration might show some people the light and might change voting, and so we've had really awful times before. There were these kinds of like really awful cases that seem to just totally violate people's rights. See, there's all these Cold War era cases, and we came back from that, so you never know. We are in a different era. So there was a period of time, there's this video clip that I like to show my students because it kind of blows their mind. It's of the presidential debate in 1980, and you have George Bush, the elder George Bush, and Reagan, right, who were debating each other, and they're falling all over each other to who's like the most pro-immigration. It's just this wild, like different time. And that reflected a lot of it reflected business interests and agricultural employers. There was a long tradition. I mean, it wasn't necessarily like a pro-immigrant, it wasn't an immigrant rights position necessarily, but there was support for more liberal immigration policies. And immigration got weaponized as an, it took a while. So there was this period of time where it did keep, so 1986 is really the last time we had anything you could call immigration reform, and it was mixed with a lot of like increased funding for border security. It was a really mixed bag, but you had kind of an amnesty in 1986, which, by the way, has happened periodically there's something called registry that gets updated every 20 years or so. It's this thing, it went in, 1924 is really when numerical restrictions went in on European immigration, and there was an immediate understanding that, oh, there's people who got caught. There was a lot of sympathy. I mean, the racial dynamics of this are so central. So when European immigration got restricted in the 1920s, there was immediately this sense, oh, this is so harsh, wait, and families are being separated, and let's figure out this way to deal with it and that way to deal with it. And there were all these paths to regularize your status. So when people say, oh, well, my family came here legally, these people are coming here illegally. No, I mean, if your immigrants were European immigrants who came in the 20s, 30s, where, there were so many paths to get your papers in order. In 1965, we'd had these really racist national origins quotas. We had Asian exclusion and national origin quotas. They finally were removed from the law in 1965. So the kind of multicultural world of immigration that is part of the fabric of our society now, is really came into existence in the wake of the 1965 immigration law. And so we have lots of Black and brown immigrants who are coming in. We have immigrants from all over, Asia, Latin America, Africa, right? And the sentiment, that kind of anti-immigrant, that highly racialized anti-immigrant sentiment mobilized. And there's versions of that. You can see this earlier in the century, or in the 20th century, against Italians, against Jews. I mean, it's not that there aren't earlier analogs, but what we're living through now, this complete resistance to this idea, that being without status is this moral failing. When for many years there was just a lot more flexibility, and you didn't get kind of labeled as something and have to stay there. It was sort of, oh, you need to get your papers in order, and people had ways to do that.
Well, there's a perfect follow-up here, which is all of this, or not, much of this immigration turmoil focuses right now on brown and Black people, and you mentioned the South Africa example. Does this strike you as a racist policy? And if so, does that provide a legal remedy for changing things?
So yes, this is 100% about race. It is, we saw this in the first Trump administration, and I won't repeat the comments that were made about Haitian immigrants, and we saw it on the campaign trail this time around. And I'll just say, I mean, there is racism against many, many different immigrant groups. But the racism that Haitian immigrants have faced, it's so central to this story. It's why I talked about Haitian interdiction, that these policies have been generalized now, but really they started with this kind of singular focus on mistreating Haitian immigrants. Like in the 1980s, you see kind of like the difference between, you get Cubans coming on boats and you have Haitians coming on boats, and the way that they're treated, there's these huge disparities. And so it is absolutely about race, and that did in fact factor into some of the litigation in the first term. So for example, there are reasons that TPS, temporary protected status, can be changed, like if the conditions in that country improve or something. But it was the president's language was so racist about Haitian immigrants in particular, and just a whole, across the board, that those arguments were raised that this was motivated by racism, and those cases in the end kind of dragged out, and then we got into the Biden administration. We didn't necessarily get final decisions about those issues, but those claims are absolutely being brought again.
Okay, there's a series of technical questions that I think are quite interesting. So what percentage of asylum applicants are ultimately successful?
Oh, I didn't bring my graphs. So, and it has changed over time. I don't want to quote any numbers because I don't know. But here's what I will say. I mean, it has changed over time, but it's not, I mean, it's less than 50%. It is hard to get asylum. And I will say here that the individual judges, like immigration judges, and asylum offices have very different grant rates. So there are judges, and there's been a lot of scholarship on this. And the term that's been used, there was a book and an article, is refugee roulette, that you're kind of spinning, it's like, you don't know what you're going to get, because there are judges who will grant 2% of the cases, 3% of the cases that they get. They just never grant asylum. And there's judges who will grant 60% or something. And there's might be different variations, but there's too much variation to just be accounted for by different groups of immigrants or different kinds of claims. And so, so there is a huge variation, I think, and the asylum offices also, there's a number of asylum offices around the country. There's been some variation as well from them. I am worried about how this is going to play out. So there's a bunch of immigration judges are not independent. They're not like federal judges. Federal judges have lifetime tenure, and they can only, they can be impeached if they do something really wrong, but otherwise they have job security for the rest of their life. That's supposed to give them independence. They can do whatever they want. They don't have to be worried that Trump's going to be mad at them. Immigration judges are really just sort of administrative adjudicators. They work within the Department of Justice, and it is not supposed to be political, but Trump has really politicized the executive branch. There's a bunch of immigration judges. Actually, I think I just saw this morning that a bunch more just got fired. So had some that had been fired. There's others that have been fired. There's a bunch of members of the Board of Immigration Appeals who were let go. And so there is, I think, going to be an attempt to just fill those ranks with loyalists. So I think we're going to see the rates go way down.
And maybe this answers that question, which is when these judges are dismissing cases that then allow ICE to immediately deport people, what's the legal rationale for the judges making these seemingly somewhat unprecedented decisions?
So, well, I think partly the judges are scared of, some of them are loyal to Trump already, some of them are scared of being fired, and so I don't want to hazard any guess about what is driving this, but I think in general, if they have huge backlogs of cases, if the government wants to take a case off their docket, they will say, they might say yes, and there is, again, this sort of, this presumption that the government is doing something in a regular way. We'll see. I have to say, I have not followed this closely because I know there is a real range of people who are immigration judges, some of whom were advocates for immigrants before. I have not heard yet of judges who have refused to do that, and I wouldn't want to, it's not an area I've looked at closely, but it would be interesting to see if that happens.
Please discuss how difficult it is to attain asylum based on gender, and I will add sexual preference.
Okay, so sexual orientation, gender identity, gender, those are all grounds. This is usually these fall under the particular social group grounds. They could also fall under other grounds. So they could fall under political opinion, for example. There have been gender-based cases where people have said essentially they were being persecuted for being feminists, not necessarily just for being a woman, let's say. The test for a particular social group case is, first of all, is it an immutable characteristic? And not literally immutable. Immutable is defined as something that either can't be changed or is so fundamental that it shouldn't have to be changed. So for example, like sexual orientation has been seen as something that, so fundamental, so, even if someone could hide their sexual orientation, they shouldn't be made to do so. So it's been kind of recognized as a particular social group. Gender as well. There's no barrier to that being recognized. There's certainly been a lot of cases, female genital cutting, there was a case that, a precedent-setting case, and that's certainly been recognized as a form of gender-based violence, and cases have been granted on that. The domestic violence cases, as I've mentioned, have been difficult, and the case law has gone back and forth, so there was some bad case law. For many years there was no case law because they couldn't kind of figure out what to do, and so each immigration judge was kind of left to themselves, so a lot of cases were granted, some weren't. Then you get a precedent-setting decision during the Obama administration, and then Trump reverses it, or the Attorney General does in the first Trump administration, then Biden comes in, and the Attorney General goes back to saying, yes, this is recognized, and I'm sure it's gonna go back the other way now. So domestic violence cases are difficult, but they're all difficult. I mean, so just because something can, in theory, be recognized, it doesn't mean someone's going to win their case. They still have to show that they are at risk. And so there's a lot of evidence that they have to put in. Sometimes it can get complicated, for example, in countries where certain advances have been made on LGBTQ rights. There's like, there's the capital city, and there's a pride march, there's all this stuff going on, but someone who's from some other part of the country might be, or even in the big cities, there can still be a lot of violence. Often, for example, advances in rights are met with backlashes of violence. So you can have both things be true. So there's a certain amount of educating judges. So they're not always, it doesn't mean they're easy, but in theory, they can be brought.
More asylum questions. So from Ali at the University of Michigan, why wouldn't any immigrant request asylum given that there's a backlog of millions of cases? And of course, once you create that incentive, doesn't it just make more backlog? So how do we sort that out?
Yeah, the backlog question it's sort of, it's come up many times over the years. So there was a period of time, like I think in the 90s, where the backlogs got very long, and people used to get work authorization as soon as they filed for asylum. So people were filing for asylum, and they knew it would be 6 or 7 years, before they had their hearing, and they were getting work authorization. So a change was made, because that was seen to be, a possible incentive. There's certainly lots of people applying who need protection, but maybe some people weren't. Other people were applying, and so they kind of cleared up the backlog and made the turnaround very quick, and also, quick, like 45 days. I remember a period of time in the late 90s where you get an interview in 45 days. And so there have been different changes over the years. So now, for example, people don't get work authorization right away. They only get work authorization after a certain period of time if their case keeps going. And so, and there's been these policies of, a few years ago, they started something called last in, first out, where they kind of just archived the backlog, essentially, and started just taking the new ones right away. So, this is an ongoing issue. You could, for example, you could hire a lot of asylum officers and deal with these cases a lot faster. You could allow people to go through the asylum office. The immigration court system really gets slowed down. Now the asylum office is pretty bogged down as well, but there are ways that sometimes it can go faster through the asylum office. So there could be some creative problem solving to speed that up. I agree. I mean, nobody really likes it. It's true, some people could maybe take advantage of it, but it's awful there are people who are seeking asylum who have a spouse and children who are in another country, and people have a very strong case, and who know that, that have a good chance of getting granted, and then their family will come see them. No one wants to wait 7 years to start that process. So I think, there should be some good creative problem solving to speed that up.
What is the likelihood that law-abiding persons with green cards might be included in some of these larger roundups, as the person describes it?
Yeah. Mostly what I was talking about was people who have no status, people who have, have something like parole or TPS that's not very secure. But this is reaching further. And so there's two answers to that. In general, if someone is a lawful permanent resident, they have a green card, the big area in which people with green cards have been vulnerable is criminal convictions, even very minor ones, things that would shock you. So there's a category called aggravated felony. It sounds terrible, right? It includes things that are not aggravated and not felonies. It's gotten very, very broad. When it first started, it was, rape, murder, sexual abuse of a child. I think there was like 3 or 4 grounds. It now encompasses so many things. So someone who sells someone $10 worth of marijuana is an aggravated felon under the law. Someone who, a crime of violence with a 1-year sentence, okay, well, that can include very minor things, because a 1-year sentence includes a suspended sentence. And a lot of places, it's a way to give someone kind of a warning. There was a famous case when this law first came into effect of a woman who had been adopted. She was born in Germany. She'd been adopted when she was 2 years old. She'd grown up in Georgia, and her parents didn't know that she didn't automatically become a citizen, or she got a green card as an adopted. Her parents were military, U.S. military. They'd adopted her when they were serving in Germany. They came back to Georgia. She just grew up as a kid in Georgia, married an American citizen, was a stay-at-home mom. I think had a couple kids, one who had a serious disability, and she went to go get citizenship. She tried to naturalize, and they looked through her record. Years before, she'd gotten in some fight with some woman who was like, they were both dating the same man. It was some little thing. She pushed the woman or pulled her hair or something. It was like very, very minor. It was one of these things where someone advised her, oh, just plead to this, assault. You'll get a 1-year suspended sentence. You'll never do any time. Yeah, she went on her way, lived the rest of her life. Turns out that's an aggravated felony. It was mandatory deportation. It didn't matter that she had a green card. The only thing you can do in a situation like that is sometimes you can get the sentence reduced. But on the immigration end, there's no discretion anymore. So people with green cards are quite vulnerable in that way. That's been an issue since 1996 of the kind of extreme vulnerability. There's something new that's happening, and I think Trump wants to go after. So for example, Mahmoud Khalil and Mohsen Madawi, who is local, I think lives right near here. Both had green cards, and Mohsen Madawi was going into his citizenship interview when he got grabbed, and I mean, that's an absurd, this is another one of these kind of extending the law beyond any recognizable realm. So in theory, right, all of the pro-Palestine protesters or students who've spoken out, right, Ramesa Osher just wrote an op-ed piece. The theory there's this foreign policy ground that if somehow somebody is, bad for U.S. foreign policy, they can be deported, and you just need a letter from the Secretary of State. I mean, it's never been used in that way, and green card holders actually have quite, it's not like being a citizen, but it has been recognized by courts for many years as someone who has a lot of stake in this, in being in this country, and you have to have a pretty good reason before you can deport someone. So those are working their way through the courts, but clearly there's an attempt to go after people with green cards. There's even an attempt to go after people with citizenship. So there's been a lot of talk about denaturalizing people, which is, again, is hard to do. I mean, for good reason. You know, that the law is set up to be fairly protective of citizenship, but it's not going to stop them from trying.
Two questions here. I'm going to combine them. Which, if any, of the concerns expressed about immigration do you consider legitimate, and how would you address them now or going forward if you were to convene a group of immigration reform people? And then the second one is, I understand your concerns about the Trump policies, but can't we criticize the Biden administration for its open border policy and allowing so many illegal people to enter the country illegally? And I would add to that, but you know, the substantive policies, and again, also the optics of them, which we know are very important.
Right. So, yeah, this is a really important question. I want to make one quick tweak to it, just in the sense that Biden, I think by definition, you can't allow someone to enter without authorization. If they enter without authorization, it's because you didn't authorize them. So the people who Biden allowed in actually entered with parole, which is something that has been used for decades to help people who are fleeing persecution. So in a sense, he's just sort of hearkening back to this long policy. It's just that it didn't get I mean, it did get some pushback actually, even earlier, but you know, not in the same way. So, and the border has become so militarized at this point. It's quite difficult to cross the border without being detected. We live in a different era now, and so the Biden policies at the border made people apply for these appointments, and then you know, evaluated them and let them in with parole. So. And in an attempt to, the whole parole program was an attempt to do this in a more orderly fashion. I think, and to me, the really big issue that comes up is the extreme danger. You know, the way we have set up our borders has pushed people into very dangerous areas. They can't cross in the areas that are more, you know, they pushed into the desert. There's hundreds of people who die every year. It's the whole path up through Latin America. I mean, you know, the statistics of women who get sexually assaulted is astronomical in that process. So that whole deterrence strategy has made this process really difficult. If the question is more sort of how many immigrants should, you know, are we letting in too many immigrants? I think it's useful to have some perspective. So, for example, the percentage of foreign-born people in the United States at this point is about 14%. Canada, it's 23%. There's a lot of perception of sort of like, oh, that you know, there's so many people, and I'm struck. You know, there's countries that let in far more people from other countries, and I'm struck by the fact that we have two different discussions going on in this country. One is there's too many immigrants. The other is the birth rate is too low, right? And this is bad for our country. And what are we going to do? We have an aging population. We don't have enough people working age. We don't have enough people to care for people. This is crisis. Let's pay people to have babies, right? Most of the immigrants who are coming in are of working age. Like there's this complete disconnect. I mean, and this gets us back to race. You know, these two questions are related. If we're worried that we don't have enough people of working age, you know, and jobs are going empty and people aren't being cared for and crops aren't being picked, all this whole concern, at some point, it might be worth getting over there are issues. I mean, immigration, yes, you need some resources. You need federal resources. I think the problem, to me, comes when local communities, there's a million different, there's a need for, there's a lot of kids who speak different languages in the schools, and there's healthcare needs, and there's this, and there's that. And when you have local communities dealing with this by themselves, there's resentments, and there's a feeling of scarcity. This is a very, very wealthy country. It really is. There isn't a lack of money. There is a lack of willingness to tax people for that. If we went back to sort of 1950s tax rates when when America was great supposedly, and we brought some of that money into local communities and integrated immigrants. Immigrants are I don't know what it's like up here, but in Massachusetts there's communities, there's towns that were kind of dying and have been revived. There's all these small businesses being run by immigrants, and so I think there's a way to kind of meet, if you meet this challenge head on and embrace immigration, it may be that you kind of avoid, it's the resentment that I think we need to avoid. I don't think it's the immigrants that we need to avoid.
Just as I hear you speak, as I think about my policy work, a lot of this is, what kind of country do you want to have in 2050? I mean, that's the big high level. And I guess I would say the Democrats have not articulated that particularly well. And the Trump folks have. It's not a view I share, right? But it does get back, like, before you can figure out what your policies are or what route you want to take, you're like, where are we trying to go? And I think you do have to be explicit about, we want young people, we want vibrant communities.
And I've seen 40 articles about falling birth rates in the last few years. I finally saw one that discussed immigration. It was like they all, it's sort of like...
The economists talk about it all the time.
Yeah, there's no connection.
Yeah. All right, back to specifics here. Tell us about Alligator Alcatraz, because we have a couple questions about that. What's going on there? Who's being sent there? What are the legal justifications?
Alligator Alcatraz is this detention center in Florida. I'm not an expert on it. I've just been following it a little bit. It seems like it is designed to treat people very badly, and it seems very unsafe, and it's been flooding, and it's people in tents, and it's a kind of it's punitive. It seems really punitive, and it's isolated, and so this is. It's on a continuum. I mean, this has been going on, issues around immigration detention. Immigration detention has skyrocketed since the mid-90s. There's a lot of people who are subject to mandatory detention. And this is one of these places where immigration, so the Constitution applies anywhere, in every area of law, but it applies sometimes it applies a little differently in immigration. Unfortunately, the courts have tended to allow things to happen in immigration. And so one of them is detention. In most areas, someone who's being held on mental health grounds or something, for civil detention, someone who has, who's not in criminal, who hasn't been convicted of a crime, they're just being held in civil detention, there's pretty strict limits. That's a really basic liberty issue, right? And so usually people can't be held without an individual determination that that person is a danger, or a flight risk. In immigration, there's a lot of people who are subject to mandatory detention. And so the rates have just, they've increased, hugely, and they're about to. The new the bill that was just passed, and the new budget has an amount that has for DHS that has never, it far exceeds any amount that has ever been allocated for immigration. So we're going to see detention go up much higher, and it's already this system. So we've got, I think at this point we're up to 55,000 people on any given night are being detained. If you had looked back in the 70s and 80s, it was, 2,000, 3,000, something like that. So there are plenty of other ways. It costs a huge amount of money too, right? It's a huge, huge amount of money. People show up at their hearings. If, people, look at these people who are being taken into custody at their hearings. People show up for their hearings if they think that there is some relief that they can apply for. So detention has been this constellation of, so there's some federal detention facilities. There are private prisons. There are, the stocks of those private prison companies went way up when Trump got elected. They're making so much money, and they have so many lobbyists in Congress, right? This is big business. There are also all these county jails in facilities that are being used, and there are communities that balance their budget by these contracts with ICE. So there's a lot of financial incentives built into the detention system, and a lot of corners being cut, and a lot of people who are the Alligator Alcatraz facility in particular, it seems designed deliberately to be located far, or to be inaccessible to attorneys. It's very scary to think about what's going to be happening there.
I want to talk about the Supreme Court, because you mentioned the shadow docket, but a lot of these cases are going to get to the Supreme Court and they're going to be decided. It is a different court, as you pointed out. It's not a monolithic court, though, even on the conservative side. So Roberts has a pragmatic streak. Amy Coney Barrett has turned out to be not entirely predictable. Gorsuch also on Native Americans. So could you talk about the justices, and how that might ultimately impact some of these cases?
Yeah, I don't want to, these days I don't make any predictions because this court is,
yeah, no predictions, but just
in general, I think you're right. So there's a couple, I think Thomas and Alito are sort of, always going to vote, always going to support what the administration is doing. The others aren't as predictable. And Gorsuch in particular, it's interesting. Gorsuch came in with a real skepticism about executive power. And this is a switch. So for many years, Justice Scalia was the big advocate for executive discretion, executive power. And so this is one of the few areas where conservatives kind of switched, where Gorsuch came in wanting to not give as much leeway to executive agencies. This is one of these questions that I like to ask my students, because your answer to, do you think that the executive agencies should have a lot of power or not? How should it, should it be the courts or the agencies? Can kind of depend on who's in the court and who's in the agency. So when it's, if you want environmental protections and there's a Democratic, administration that's trying to do good, progressive things on environmental regulations, and the courts are striking them down, you say, I want
the perfect example,
to have
Obama making carbon dioxide part of the Clean Air Act, and everybody cheered, and that was an executive action.
Right, and then if you see an agent, if it's not if the people in power are doing things you think are bad, and you think they're kind of out of control, you want the courts to step in. So this is always a little politicized, but Gorsuch seemed to come in very skeptical of executive power. You would think that that would come in handy, and maybe some of it will. But on the whole, these decisions so far have been highly partisan. I will say it's disappointingly so. I would like to think that people will just stick to their principles, but there have been, if you just sort of look at the the Biden administration, the things that got struck down in the Biden administration, the things that so far Trump has been allowed to do, there's just too much of a disparity. So unfortunately, I don't have a great faith in them. I'm hoping that, I think Roberts cares about the image of the court, right? There's this question of, there are people out there who still care that who want the court to be respected. I don't think Thomas and Alito care about that. I think Roberts sometimes seems to, certainly in the first Trump administration, the DACA case, and there were cases.
The Affordable Care Act, right? That was the fifth vote to uphold that.
Right, so that's the Deferred Action for Childhood Arrivals, which was the Obama administration policy that gave people some temporary status who would come here as young people. So I'm hoping, but I don't think we can put our faith in the court. There will be cases that don't go up to the Supreme Court. I mean, that always happens too, is there are some cases that get decided lower down, and those I think are going to be more favorable. But all the big cases I think will end up before the court.
Okay, two last questions. One's kind of depressing, one is more optimistic. We'll go depressing first because we want to send people out on a happy note. What are the barriers for a U.S. citizen who fears persecution and might want to apply for asylum in Canada? This is the depressing one, just to be clear.
Well, this is on people's mind. Well, depressing, although, yeah, if you get a new start somewhere, maybe that's hopeful. Wasn't there, wait, is it new? I think it's Vermont. There's a state legislator, I think I just saw, who resigned and is moving to Canada. I mean, this is happening. I think it's on people's minds. There have been people before who have sought asylum in Canada. I think, what I'm struck by, so Canada does have a good asylum system. They've, in general, had a fairer asylum system, it seems to me, at least from a distance, less politicized. So when we were struggling over domestic violence cases, they very quickly said, yeah, this is absolutely fits, and they didn't end up with, zillions of people. I mean, they just they went with what they thought was right, and they didn't worry about how many people it would be. So this could happen. What I'm struck by, I mean, I think we're already in this moment. So, I live in Massachusetts. There are trans people who are moving from state, and for whom life has become impossible in many states, who are moving to places like Massachusetts and Vermont, I think, might be another one. There are certain states that are more protective of people's rights. And so those in refugee law speak, those would be internally displaced people, I would call those. We don't use that language. We think of that as something in other places, but I absolutely think we are already seeing this happen, that there are places that people can't live in this country. And so the standard for asylum is it has to be countrywide, usually. So you have to show that you couldn't internally relocate, right? So it has to be that your whole country is off limits, and there's some exceptions to that. But so if someone goes to Canada, they have to show there's nowhere that they could live. It's not that they could just move to Massachusetts or something. I'm not sure we're there yet, but I think we're getting, we might get there. So, and I do think that countries will take these claims seriously.
Now, the hopeful question, you teach this, your students are, fair to say, younger than this crowd, younger than me. They're going to be around 2050, 2060. They are going to go out and build the society that they want. So what do you tell your students to keep them hopeful and to make them feel a sense of agency about this system going forward?
Well, first of all, I think it's a tough time I teach law students. It's a tough time to go out and practice law. I mean, the norms are just, there's always been a lot of work to do, right? There's always been bad policies to be, if you're going out and doing public interest law, some policy you disagree with. So it's not like everything's been perfect ever. But what I'm struck by is how much the norms have changed. And I'll just mention one thing that I read about this yesterday, and I kind of couldn't believe it. It's not the worst thing that's happening out there, but it just seemed like a marker to me. Not only are people being picked up by masked agents in immigration court, but a new development is that the lawyers for the government are not identifying themselves in court. They're not entering an appearance, which, so there's this kind of professional courtesy among lawyers. And you have to communicate with the other lawyer, and I guess the lawyers for immigrants are being told, go through this app or something, some portal if you need to reach the attorney, and they'll reach out to you. It's shocking. This is just unprecedented. And so it's a weird time to go and practice law. Even if the policies are bad, and even if the case law is not on your side, there's certain norms that you feel like, the rules of the game that you need to be able to go out there and practice, right? And you need to feel like government attorneys, the attorneys who, in the Office of Immigration Litigation within Department of Justice, I mean, for years, they have been going in there and, defending the government representing the government on policies that I think are terrible. It's their job. They work for the government. I'm not, I don't necessarily want that job, but they have done it with professional ethics. So, this has come up recently. Kilmar Abrego Garcia clearly was deported by accident, and the attorney who first appeared admitted that this has happened before. And so they might defend some bad policy, but they're going to come in and they have an obligation to be honest with the judge, right? He got fired for it. He's now a whistleblower. So it's a strange time to be practicing law. I do tell my students, though, I focus on all the cases that are all the really important lawyers. People need lawyers right now, and there's a lot of this work is winning at least before the district court judges. So I focus on all the work there is to do, and also I think a lot of my work is historical, and so I'm always thinking about the awful times we've been through before in this country. I mean, the era of Chinese exclusion, the era of Japanese, the incarceration of Japanese Americans during World War II, the forced so-called repatriation of Mexican immigrants, many of whom were actually citizens during the 1930s and the 1950s. I mean, there's been such lawlessness in immigration enforcement over the years. And it's really good that people did not give up fighting, because better times did come. A lot of those policies we had racial restrictions on naturalization until 1952, okay? Asian immigrants were racially barred from naturalizing until 1952. There have been terrible times, and people fought all of these policies. They fight them in court, but they also fight them politically, right? We can't just win this stuff in the courts. So I think that's another thing I tell my students.
And what I tell my students in public policy and at the business school is democracy's not like the Cubs, where you just hope it gets better. It is, if you're not involved, you're leaving a vacuum for somebody else. And I will offer a book recommendation, John Meacham's book. I think it's The Better Angels, which talks exactly about that, which is, look, we've had there were 30 million people in the Klan. This was not 27,000. Yeah. And McCarthy, in every juncture, it was the good people facing down the forces that were not great. So thank you for your work, for coming. Yeah. Thank you all for listening.
Thank you for having me. Thanks for all the great questions.
And there is the follow-up discussion, I think, that starts at 11:45. So again, thank you all. Thank you, Rachel.